I tend to share largely the opinion of the justices of the Supreme Court and the President this morning. More often than not, I think that the seniors in chambers should do well to have the juniors in office at least understudy and get acquainted with the nuances of the Supreme Court practice, because they throw them there. The Supreme Court is needless to state, is the highest court of our land, and it is not for anything that it is called the Supreme Court. At the time that we were trained as lawyers and we were attending court with our seniors, when you came to the Supreme Court, you saw the caliber and age of lawyers who came to the Supreme Court. That is not to say that the other lawyers who were not up to that age limit were not good lawyers. But you see, the more you study something, the more you get used to it. In every vocation, you can get better after a number of years of work, and then experience comes in. You can have exceptionally good, brilliant students, yes, but it is an exception to the rule, but not the general rule. So I would advocate for the same position I came to meet. I would think that, yes, you can be coming to the Supreme Court with your genius, but you bring them to come and study and get acquainted with what happens here before you throw them onto the rules. Because most of them are not, even when senior lawyers come here and they are being bombarded with questions all over from the panel, it becomes sometimes a bit embarrassing, because then you'll be able to find an answer for one judge. Just before you are landing, another judge is asking you the same question. A junior will not have the same level of expertise, skill, and experience to answer those questions. That is why it is not as if we want to stifle any genius initiative, but it is in the junior's best interest, because when a junior repeatedly goes to court and he or she gets embarrassed, the confidence of that junior diminishes. The next time you ask the junior to come to court, the junior feels frightened. So yes, I think that there's no other reason why our legal profession act stipulates quite clearly that you only become a senior after 7 years of practice at the bar. You see, the Supreme Court is supposed to be a court, with all due respect, for senior practicing lawyers. That is why it's the highest court of the land. So what happened this morning, that was very distressful. I thought, when I was sitting in my chair, I was cringing, because I was imagining myself that if I was the lawyer being treated in this manner, with my client looking at me from behind, it would seem as if I don't know my job. But it will not be too much of my fault, because my senior has asked me to come to court. I cannot say no to my senior. But I think that the seniors will do well to also regulate what happens.
So respectfully, would you subscribe to a directive from the CJ in that respect?
Exactly so. It used to be the case in the past. I don't know why it has slackened. But in the past, if you get to the Supreme Court and they ask you one or two questions, and they find out you are faltering, they will ask you who your senior is. And then they ask you the number of years you are at the bar. And they don't do it for nothing, because something of the sort, the letter will be sent to the senior to explain why you have sent a junior of less than 5, 6, 7 years to the Supreme Court, knowing very well that that senior is not well equipped for the practice in that court. So yes, I will subscribe to that a directive, general directive should be given, so that at least the juniors will come and understudy the seniors before we throw them on.